Okay, thank you. Thank you for that. So I'd like now to move to the next submission, which is an oral presentation by the concerned citizens of Renfrew County and area, as outlined in CMD 18H2.8 and 18H2.8A. I understand that Dr. Hendrickson will make the presentation. The floor is yours.
Thank you. For the record, I'm Ole Hendrickson with Concerned Citizens of Renfrew County and area. With me are Joe Castrilli and Rizwan Khan of the Canadian Environmental Law Association. They're available to answer questions. First, I'd like to acknowledge that the CNSC has already acted on some of the recommendations in our submission, that the a revised CMD should have an expanded section on proposed license changes that documents and explains license changes, and that that there should be some description of the standard license conditions for Class 1 nuclear facilities that have been introduced into the new license. And there's also, I'd like to say that we're pleased with the pilot project to include nuclear submissions, submission to CNSC online, and we strongly recommend that that continue to be done. There are 7 decades of accumulation of waste on CRL. I'm going to skip through this pretty quickly, but I think it's important for people to know that it's research and development meant in the early days of CRL development of nuclear weapons. And that's a well-known fact. It's on the CNSC website, but that creates a wide variety of long-lived activation and fission products that are very difficult to manage, and the NRX accident in 1952 contributed to that legacy of over 500,000 cubic meters of waste. Just for scale, that's equivalent to about 4,500 tractor-trailer cargo loads. And the estimates to clean up CRL vary a lot, but the 7.6 billion is from the AECL's 2013 basis of cost estimate, which is one of the documents referenced in the license application, and I believe in the handbook as well. I'll just briefly say that this isn't been ignored, that there's been a nuclear legacy liabilities program, but that operated for about 10 years, and then when the GOCO model was implemented in September 2015, that was terminated after spending about $1.22 billion. We just got this basis of cost estimate document from AECL through access to information. It's heavily redacted, but there is this table which gives you a little more detail on the $7.6 billion liability, which is on the books of the Government of Canada at the Chalk River Labs. And this is also from that basis of cost estimate document. It's just, it's 10 of the plumes at the Chalk River site that are contaminating groundwater. You'll notice the inset map with the what they call the active, we used to call the active area. They're the 2 plumes from the NRX and the NRU fuel bay. And you'll notice 4, 5, 6, 7 are the around waste management area A, very close to where the NSDF would be, and plume 3 is from waste management area B, where there are 2 reactor cores buried in waste management area B and 1 reactor core from the 52 meltdown in waste management area A. The Government of Canada has greatly increased the amount of money going into decommissioning and waste management for Chalk River. In the past 2 federal budgets, there's over $500 million in each. So if you multiply that times the 10-year proposed license period, we're talking about a $5 billion expenditure from the taxpayers of the Government of Canada. That's not all for Chalk River. Some of it's for the other CNL sites. But this is a lot of money, and it's a lot to expect to spend this without having opportunities for the public to intervene and talk about things like the NSDF, which, as we know is out of scope for this particular hearing. However, there are concerns about what CNL would propose to do in this 10-year license, such as the bulk demolition approach, which hasn't been discussed here, or moving away from environmental remediation of Waste Management Area C, for example, to in situ abandonment, essentially, of the waste in that waste management area. These are things that I think the public should have an opportunity to talk about, as well as the plan of CNL to consolidate all the federal wastes from White Shell, Gentil, Douglas Point, at Chalk River, including moving all the high-level waste fuel rods that are currently at these sites to Chalk River, even though there's no appropriate facility at present for managing those kinds of waste, either storing them or disposing of them. And of course, disposal of high-level waste is not feasible at Chalk River because of the highly fractured nature of the bedrock and the seismically active faults that run down the Ottawa River very close to where we are right now. So these are new activities that the license apparently would allow, but there hasn't been any real public discussion or analysis opportunity. And that's just a map showing where some of those CNL-run facilities are. The waste management provisions that would guide this type of activity are really out of date. The CNSC document P290 is over 10 years old now. There's been a lot of IAEA guidance and advice that's really pertinent to managing waste that simply hasn't been adopted either by CNSC or perhaps by the Government of Canada, because it has a major policy role for managing these types of very long-lived waste that will be around for thousands to billions of years. And I just took a table from, I know this is from the NSDF EIS, but this is their waste inventory. So these are the kinds of wastes that are currently the responsibility of the Government of Canada via ACL. And you can see that many of them have half-lives of thousands to millions to billions of years. So this is not a trivial matter. And we're very concerned about the proposed demonstration facility for a small modular reactor. We know that 3 of the consortium members are very interested in this, but again, this means more waste at the Chalk River site, and a really rigorous and publicly accessible program for dealing with it is essential if there's going to be any sort of social license to go in this direction. So our conclusion is that we don't have adequate provision for protection of environment and health at Chalk River at present because of the current approach to nuclear waste management. And I know a lot of you want to get into the watering down of the license conditions and the deletion of the compliance verification criteria. This is an important topic, and so I really want to leave a little time to explain our concerns about that in my remaining 3 minutes. And just there is an opportunity. I don't think everything should be on the CNSC. The Government of Canada itself could do something called strategic impact assessment and look more broadly and holistically about how its nuclear waste can be managed more safely. In terms of the proposed changes to the license, I would direct you to page 28 of my of the CMD 18H2.8, where I discuss some of the provisions. And since we're focusing on waste here, I'll just say that some of the criteria that would be deleted are the requirement to document the characteristics of all radioactive and hazardous waste produced at CRL or accepted from outside clients, to obtain appropriate authorization of waste management activities, to minimize the production of radioactive waste, to maintain accurate records of radioactive waste, to prevent undetected leaks of radioactive waste, and to ensure as far as possible that radioactive waste cannot escape from control or containment. These are all in the current CRL handbook. Are they in the proposed new CRL handbook? No, they are not. What is in the proposed new CRL handbook? Well, if we go to page 28 of the supplementary CMD prepared by CNSC staff, they talk about the draft license condition handbook says that requirements for handling, processing, storage, and safeguarding waste are all covered under CSA standard N292.3. Well, I was able to go to the CNSC library and read CSA standard N292.3, and I put a little appendix in which, if you turn to page 44 of the CMD 18-H2.8, I talk about what I found in CSA standard 292.3, N292.3. It's on page 44. N292.3 explicitly excludes issues related to radioactive waste disposal. So nothing about radioactive waste disposal is discussed in that. It has no reference to control or containment of wastes, no reference to ensuring that no leak or escape of waste can occur, no reference to minimizing waste, no reference to adequate waste record keeping, and it lacks the text. The application of this standard is mandatory when referenced as a requirement in a CNSC license, even though that is present in some of the other CSA standards. So in no way, in my opinion, and the opinion of our group, does this CSA standard N292.3, which replace what's in the current handbook. So management of low and intermediate level radioactive waste is a huge gap of major concern to our group, and I think many other people who are attending this hearing, and it's one that we think justifies restoring and strengthening conditions that are currently found in both the license and the CRL handbook. Thank you.
Thank you. I'm not sure we could follow all the argument back and forth, because if we're going to go in the particular example you gave about waste, I want to hear from staff. Is he right?
So Haiti Tadros for the record, sir. So what we've laid out in our supplemental is the proposed license condition that will be captured with regards to the requirements for a waste management program, and that correctly, as identified, is on page 28 of staff's supplemental CMD, and the compliance verification criteria that is currently being proposed to be included in the license condition handbook as the criteria by which CNSC staff will conduct compliance verification activities on. And rightly noted, a lot of the CSA clauses that are included, 292, are found in the license condition handbook with the compliance verification criteria identified. So what I'd like to do to give an overall perspective of the CSA standard and some of the words that are currently found in the existing license condition and what is found in the clause of the CSA standard N292.3, I'd like to pass the mic to Ms. Corinne Glenn in Ottawa. She is our waste management specialist, and she can describe what the CSA standard, not just 292, includes, but the other standards that are also referenced in the license condition handbook.
Corinne Glenn for the record. I am the director of the Waste and Decommissioning Division at the CNSC. I am also the vice chair of the CSA N292 Technical Committee. So CNSC is involved in the development of those standards and plays an active role in the leadership of that committee. And so the intervener speaks that 292.3 doesn't specifically reference waste minimization and characterization. Those aspects of waste management are covered under CSA Standard N292.0, which is an overarching standard which applies by reference to the other standards of the suite of the waste management standards that CSA has put together. So 292.3 incorporates by reference the appropriate sections of 292.0 and those clauses as applicable, especially those talking about waste minimization, waste characterization, record keeping, are found in 292.0. With respect to record keeping, the CNSC regulations also stipulate record keeping requirements. I want to touch briefly about P290. And while it is an older document, it elaborates some very high-level principles that are consistent with the Government of Canada's policy framework for radioactive waste. And those principles are still applicable today. They're motherhood statements, if you'd like, with respect to ensuring the long-term impacts of waste don't exceed the allowable environmental and regulatory requirements in place today, that there's no transboundary issues, that will be the generation of radioactive waste is minimized to the extent practicable. And those are all consistent with what we find in the CSA standards as well. When developing regulatory documents at the CNSC, we try to minimize duplication. So if there's already CSA standard that addresses, rather than duplicating the work that's already been done as part of that standard, if it's appropriate, we will just reference the standard rather than duplicate those requirements in our own documents. The information found in P290 that the intervener referred to is still current, it's still applicable, and we will be rebranding that information under a new reg doc number, which is 2111, that will be published this spring. But the statements that are found in those will actually not be modified.
Why is 292.0 not in the table not made reference in the current LCH?
Haiti Tatters for the record,
It's
sir.
currently referenced as guidance, and some of the other interveners have pointed that out. Because it is, as I mentioned, incorporated through reference by the CVC reference of 292.3, for instance, it is binding. Those clauses that are referenced are binding, but we do understand that it would be clearer if we move that standard into the CVC portion of the LCH, and we will take that recommendation into consideration.
Does that answer your question?
In part. I guess for somebody like me, or it just kind of raises the question, why do we have, what is the purpose of a license if all the documents are someplace else? And the license just repeats over and over again the phrase, shall implement and maintain a program for waste management, a program for training, a program for this, a program for that. What is wrong with having more clarity and more detail in a license so the licensee, the regulator, the inspector, the public can see what it is that's needed to be done, to be in compliance and to be safe?
Well, I'll start with CNSC and then with staff, because we heard previously from OPG and from CNL that they like it because it gives them more clarity, because this is nuclear. You're going to get into some gory details. Staff, go ahead.
Jean Leclerc for the record. Just a few things to clarify. The License Conditions Handbook, by referencing regulatory documents and CSA standards, all those documents readily available. The challenge we have with the current license conditions handbook is in fact over time we've kept pulling certain words from different standards or documents and putting them in either explicitly in the LCH or in the license condition, and the end effect with that is it starts to get quite large, and the problem is you can never capture everything that's already in the regulatory document. And then where you start running into confusion is, and I believe one of the interveners earlier mentioned it, is that people now start judging, well, if it's not really written explicitly in a licensing condition, then is it applicable? Is the regulatory requirement applicable? And this is why we spent a fair amount of time in the supplemental to clearly lay out that it's the entire document, the license conditions handbook together, that form what we deal with when we're trying to apply regulatory compliance. So the LCH lays out the compliance verification criteria that we will apply. But I want to reiterate, the regulatory documents and the CSA standards are available. In fact, we've made sure of that to make sure that people can read them. So it's not that that anything gets lost. It's more a matter of, and in fact, one thing I think is that I can mention even my own experience. I've now gone through 7 or 8 license renewal hearings on different files. And I found this particular license a very challenging license to try to apply and enforce as I became director of the division. Because when I was reading the text, I almost had to ask 4 or 5 people to understand why certain words were there and why other words weren't there. And this is where you get into these variations of interpretation, and that in turn leads to lack of clarity. And so that's why we've really worked hard at trying to improve this. The other thing I think it's very, very important to put forward is when we say we haven't taken any of the requirements out of the what's in the LCH, we really mean that. And the LCH is a draft. It's something we've put forward so we can show here what we've been doing. But certainly if someone points out something that we've missed, we certainly will put it in there. Because the whole idea is clarity of requirements, clarity of expectations. So a lot of the things that Mr. Hendrickson mentioned clearly are fundamentals to waste management. And there's certainly no intention of losing any of those basic fundamental principles that we know and that we expect in waste management. Ms. Glenn already did clarify that in fact we haven't lost anything. But again, I want to reiterate, it's a draft license conditions handbook. And if we do identify something that we've missed through the process of doing, as you can see, is a fairly substantial exercise, we'll put it in there. We're not trying to remove any requirements. That's not the intention of what we're doing.
CNL?
David Cox, for the record. At risk of repeating what I said earlier, I'll say it a little differently, that we've reviewed the draft license and license condition handbook, including the reference codes, standards, and reg docs, and do not believe that it constitutes a reduction in the requirements that need to be met. In fact, it provides needed clarity. 2 points. I think there's a confusion I see in some of the interventions around quantity versus quality, or similarly repetition versus clarity. And I think what we're looking for is clarity in the requirements, and the way that that's being achieved is by single reference to the code, standard, or reg doc that is applicable, as opposed to paraphrasing some of those requirements, which was the approach previously in some of the earlier versions of the license condition handbook.
Thank you. Question? Who wants to start? Dr. McKee, sorry?
Yes.
Go ahead, Dr. Swan.
My question to the intervener. In page 41, recommendation number 22, you said that CSA standard 292.3 is not accessible. And it looks like in page 44 it was accessible, and you get 1 full page from that CSA. So does that mean some of your does that mean some of your recommendation is not valid?
In order to access 292.3, I made a special trip to 280 Slater to the CNSC library. You have to call ahead of time. They were kind enough to allow me to go online and actually extract phrases from that standard, search and extract, which is not possible for the public to do. I've tried to actually access the CSA standards, the nuclear standards. I just tried a few minutes ago, actually. There's a sort of a web page on the CNSC website, which in theory leads you to those standards, but I was unable to access any of the standards. I just wanted to check and see if that facility is operational. It may be, but it's not easy to use.
Okay, this is really, this would be a concern if that is true. So I'd like some clarity on this. As you know, we're very active, staff is very active with the CSA. In fact, I understand you contribute a lot of funds into that. So what happened here? Why is it not accessible?
Haiti Tatters, for the record, you are correct, sir. So we have Mr. Brian Torrey in Ottawa, who actually sits on the Canadian Standards Association committee when they're deliberating. So perhaps he can give you a feel for our involvement in the CSA standards, but more importantly, and speaking to the intervener's concerns about the CSA documents being available from our website, I think Brian can also provide some clarity there.
Hello, it's Brian Torrey. I'm also the Director General of the Regulatory Policy Director here at CNSC, and I sit on the Nuclear Strategic Steering Committee that oversees development of the CSA standards. I'm not sure why the intervener had trouble accessing the site. It is a fairly simple process normally. I actually did it earlier today myself because I thought this issue might come up. And I enrolled with another email. I already had an account, so just to see how it worked. And it took me about 5 minutes, and I was able to access the site. And what the view access normally allows is you can view any of the standards on screen. You can search any of the standards on screen. You could zoom in. You just can't download them because they're copyrighted material. However, if you wanted to quote them or reference them, there's a form that you can fill out, and CSC or CSA, the CSA group then would authorize you to reference the standards. The CNSC pays a fee of about $20,000 a year to allow that public view access, and it's part of allowing access to our broader regulatory framework. In addition to that, the committees that develop the standards are essentially open to the public. They have a varied participation that includes industry, members of the public, academics, etc. So there's opportunities there to participate. It's just a question if you have expertise and the time to volunteer. So those are just a couple of ways that you can get involved in the CSA process.
Are you okay with it? So I don't know why you couldn't. You should try, and if you can't, you should. You heard the name, Brian Torrey. So there's something. There may be a technology glitch here, but I don't know. I will have to actually test drive this and see if it can, and if you can get a hold of this, we'll resolve this because we pay for it to be resolved. Go ahead.
Can I break the fourth wall for a sec here? So prior to this meeting to prepare, I test drove the interface. So what I found awkward with test driving the interface is, one, you have to register. Because you become a member, you can put comments and you can deal with the standards. So you register, you have to give some personal information, which is an issue, like your title, your company, and your email address. And then I was able to get all the books, all the standards. The interface is a single page. You can't. There's no search elements. You can go from page to page to page. You can't print or copy, but you can see the whole standard. So I did test drive that because I wanted to see how awkward it was for a member of the public to get access to it. And perhaps one of the recommendations is to find a way to make that a little bit more streamlined. But it is accessible. I did it like 2 days ago.
Okay, gotta move. Questions? Dr. McEwen.
Thank you, and again, thanks for the submission. I found it very helpful. In several places in your submission, you talk about the length of the proposed license, and you've obviously got concerns about a 10-year license as it is proposed. Could you give a synopsis of the reasons why you feel that would not be the most appropriate way for us to go?
Yes, certainly, and thank you for that question. I did anticipate. One thing is that I think there have been some real positive changes as the result of this licensing hearing. For example, I talked about the pilot project to put all the submissions online. We've asked for that in the past. But more fundamentally, there are a lot of changes in the works at the CRL site with maybe upwards of 100 buildings coming down. I know we heard from Mr. Lisinski that they're sort of starting on the easier ones and getting their staff more familiar with the decommissioning process. But they're going to have to tackle some very difficult waste management and decommissioning challenges. And I think this hearing actually demonstrates the value of having not just the public, but we heard a very powerful presentation from the Algonquins of Ontario. It's not just us, but it's the commission members as well, to have an opportunity to interact with the public on a more regular basis and not wait 10 years, or it just becomes a sort of two-way interaction between CNSC staff and the licensee and the public. And I think we're seeing that the public concern and awareness of the problems there is growing. So you want to give the public, and First Nations, I might add, an opportunity to really participate in a forum like this. And 10 years is way too long. And there will be major changes, and we do have a relatively new site operator as well.
So if you were going for, recognizing that there is a considerable amount of work to be done, to be planned, how long a license would you feel would be reasonable, recognizing that we have the annual report? How long would you feel was reasonable to give the operator a chance to actually get some work done and provide some clarity on likely outcomes? Well,
We're in the tail end of a 17-month license, and we've had a fair bit of interaction about that period of time. But I think 3 years, because we know the GOCO model will be up for review in 2021. And the Government of Canada and ACL's review of the performance of the CNEA consortium would profitably be informed by this kind of discussion. And perhaps we'll be really happy, and we'll see, as a result of this interaction that we're having today, that there will be a lot of positive changes, and hopefully not a nuclear waste mound. But yeah, 3 years, particularly because of that contract review period.
Thank you.
Well, staff, there's and CNL, the U1, and maybe ACL, you said the GOCO will be under review. That wasn't my understanding. There may be another contractor, but the model itself will continue. If that's the way I understood the model. So maybe we should ask ACL and then CNL on this.
Thank you. My name is Shannon Quinn, for the record. So with respect to your question around the GOCO model, you are correct in saying that the model itself is not up for review. What I understood from Dr. Hendrickson's intervention was that he's suggesting that the contract has an initial 6-year term and then a possibility of a 4-year extension. So I believe he was referring to the end of the initial 6-year term, at which point it will be at AECL's discretion in order to exercise the option for the 4-year extension or not. And Dr. Hendrickson is right that AECL, as part of its job, does review the performance of CNL. We do it on an annual basis, and indeed, there will be a determination and a review of the totality of that performance as we approach that option period. But where I would see it differently is that there is no reason why the license would be aligned with any kind of decisions around contract or not. So the GOCO model itself was deliberately set up such that CNL would be an enduring entity. And what is meant by that is that contractors can come and go, but CNL will remain. CNL will remain a legal entity. It will remain the employer. It will remain the license holder. And there are provisions in the GOCO contractual arrangement to see that CNL will continue to be able to deliver on all of its obligations, including remain in compliance with all of its license requirements, whether or not the contractor changes or if and when the contractor would change. So by virtue of that, I see no relationship really between the term of the license and any kind of terms of or durations of the contract, because it was simply designed that CNL, as the licensee, would always be able to continue irrespective of any changes in contractor, whether it be at the end of 6 years or at the end of 10 years or otherwise based on other decisions and clauses under the GOCO provisions.
So just for further clarity, just take us through a scenario in which in 3 years you decide you want to change contractor. What would happen? What would happen the day you decided to do? The sky will fall. I'm trying to understand what's the doomsday scenario here that everybody's worried about.
Shannon Quinn for the record. In no scenario do I see doomsday. So there are a variety of scenarios. As AECL, what we anticipate is that either at the end of 6 years or at the end of the possible full 10-year contract term, that AECL will decide to undertake a transparent and competitive process to issue a new contract. And of course, it's possible that the existing contractors would compete in that process, and we have no way of prejudging who would win that type of a competitive process. But we expect that the scenario will be that it will be done in a fashion to see a new contractor being determined such that there would be a very well-planned and orderly transition between contractors, should that be the result of the competitive process. That said, I've already made reference to the fact that, of course, as in any major contractual relationship, there are termination provisions in that contract. That's indeed the case here. So it is possible, although I would say very unlikely, that the contract would end at a time that is neither at that 6-year nor 10-year period, and that in a scenario where it ends and there's not been an opportunity to complete an open and competitive process, we are in a scenario there where the shares of CNL would then very likely come back and be held by a government entity. It could be AECL. but it's not necessarily that. There are other government entities that are specifically set up to hold shares. CDEV is an example of one of those entities. But I want to be clear that even in that scenario, which has always been contemplated as a possibility, CNL will continue with all of the necessary skills, expertise, qualifications, and certifications that would be needed in order to remain in compliance with its licenses and to be able to deliver the work that AECL expects it to do.
Thank you. CNL, you want to add anything to that? Just one, after him.
Thank you. David Cox for the record. So I'll speak to a few points of clarification around, I'll say, the characteristics of CNL as the enduring entity and the licensee, I think, which is very important and central to this discussion. One of the foundations upon which we've based our proposal for a 10-year license is the performance we've demonstrated through the current license period. That performance comes from really two areas of strength. It's the 2,800 people at Chalk River, or the 3,400 people that make up CNL overall, the skills and experience, the training, the knowledge that they possess, so it's the people. But the second element is the processes. We have strong processes that are used for ensuring we conduct our activities in compliance with the license and all of the requirements that are entailed there. And our strong processes are built on the decades of experience that CNL, or formerly AECL, has existed under. More recently, we folded on top of that experience exposure to international best practices that come through the connections under the GOCO model, those connections coming from our shareholder organization, or CNEA. But independent of whether the shareholders change, CNL remains. CNL will remain as the licensee and the enduring entity possessing the skills, knowledge, and the programs and processes that are necessary to maintain compliance. So that's an elaboration on an important element of the discussion, which I think Dr. Quinn is referring to in terms of resiliency in terms of changeover if shareholder changes. Okay. The other, I'd like to make the case, though, that 10 years is appropriate for a number of reasons. And you asked about the scenario in which the contract might change. And if we look at the scenario where CNEA continues to operate through the full 10 years of the contract, that would expire in about 7.5 years from now, so in 2025. At that time, as Dr. Quinn mentioned, there would be a bidding process, select a new contractor, and a number of elements would come into play. But CNL would remain as the licensee and the enduring entity throughout that process. But what would the contractor do, I think, which was the question, what's the scenario or what would unfold? And that would be the new contractor, if in fact it's a new contractor, would come in and evaluate, develop their own long-term plan, and within 1.5 years of assuming the contract would be in the position where they would need to make a license application for the next period of time. And I think that's a reasonable and appropriate timeline to ensure that a new contractor could come in and execute the long-term planning, evaluate the lay of the land, the horizon, and bring their vision to the new contract, and then have a year like we've had. You need to apply for a new license a year ahead of the expiry of the current one. So I think that's, from a business planning perspective, I think it's an appropriate scenario that provides certainty, and it allows a new contractor to lay out their plans and articulate what that plan would be for the next license period. Okay. I'll also note that previous licenses for Chalk River have been strongly influenced by the NRU reactor. There was, in the past, a lot of uncertainty around the necessary completion of the necessary upgrades to NRU in order to maintain safe operations. And so our past license durations were strongly affected by that, and the most recent One was by the introduction of the new GOCO model altogether. But as Dr. Quinn has mentioned, there's not an anticipated change to the GOCO arrangement. It's only change to the shareholder, if indeed that takes place. So a 10-year license provides a certainty for long-term business planning. It provides for appropriate transition from one shareholder to the next. And in the middle of that, CNL remains the qualified and experienced licensee with the people and the processes to ensure that compliance is maintained in place throughout the turnover period.
I think we have to follow up. Dr. Solomon?
Still remain that CNL and the contractor are forming one management team to run the company. So what is the division of responsibility between the two, and how you settle disputes if it happens between the two organizations? There is a dispute, how you are going to resolve that? What is the mechanism?
Mark Lisinski for the record. Thank you for that question. Well, first of all, it's not that there are two different organizations. In fact, the way the model works is as the executives that are being fed into CNL from the parent companies with the appropriate expertise to match up with what our missions are and what the particular things that we're going after, as I mentioned during my opening comments. When those individuals come to the site and are seconded into CNL, they leave their other company's hat behind and put the CNL hat on nice and tight. And that team then that's formed, which is what we have right now, we have long-term CNL executives that are on our team, as well as we have individuals that have come from the parent companies that come in, and that's what we make then a team that works together regardless of which is their parent company or where they came from. So that's a real important aspect to think about that. However, behind that, when you look at it from a licensing standpoint, we have a succession plan that has in place individuals that can back up every one of us to ensure that all of those capabilities are there if, for whatever reason, all of the people from the parent companies disappear overnight. We still have the capabilities, and we can still maintain the license compliance and the safety of the site.
So what you are saying basically is that it is one unified group management, and there will be no dispute at all between the two organizations?
Right. Mark Lisinski for the record. There is only one CNL organization.
Okay.
I assume there's also the mothership, ACL, and the government to put some long-term objective on the long-term plan. So there's another player here. If things don't work, mother can come and take it all back.
Do you want me to respond, or?
I'm trying to simplify this complicated concept.
Right. So, Mark Lisinski for the record, absolutely. AECL is the owner, yes, but they are overseeing us as well, absolutely, to make sure that team that is there is fulfilling the needs for the site, are executing the work that's put in front of us each year on an annual plan of work that we establish, and we're graded upon that. And they're a very demanding customer, which is appropriate for the Canadian taxpayer.
Dr. McKeown?
I'm going to pass. Thank you.
Okay. Mr. Silly.
Maybe just on this theme of a change in contractor. So in the event of a change in contractor, presumably AECL would have some provisions for an appropriate transition of senior management and the executive team. So we wouldn't want to see a change in ownership in the contract, and then you lose all of your executive and senior management from CNL. So there are provisions for that transition.
Shannon Quinn for the record. Indeed, there are provisions in the GOCO contracts to provide for, as you say, a smooth transition. But maybe I'll bring a little bit more specificity to that, in the sense that, I think part of where I guess some of the confusion comes in is that when we talk about the changeover in contract and potentially change out of those senior executives, in the context of the GOCO arrangements, the term for those people are key personnel. Currently, there are 8. So when you put 8 people in the context of 2,800 people, I think it gives people a better sense of how it is that you could have the CNEA organization disappear overnight and still be able to have continuity of operations, continuity of safe operations, because the vast majority of those people, and indeed all of the processes and procedures that would see the site being operated safely on a day-to-day basis would in effect still be there. What you would have is a change out at the senior executive level. So in the scenario specifically that you were contemplating, where it is a planned and orderly transition, there are provisions in the GOCO contract that will see that the exiting leadership does cooperate in that particular transition. But in answering the question, I would also point out the fact that we've already been through this one time. So back in September of 2015, when the GOCO model was first put into effect, we saw this very process play out for the first time. So what you saw at that moment was a change in those senior leadership positions. And then what we had was continued safe operations. What that change out meant, in effect, really, was that some of the strategic directions of the organization were rethought, and that was put in the public domain in the form of CNL's 10-year plan. And some of the priorities and directions of the Government of Canada, of course, reflect some of that and are put out in the public domain via AUCL's corporate plan, as is our duty as a federal Crown corporation. And so maybe I'll just build on one of the points that Mr. Cox was making around some of the possible benefits, in fact, of having the expiry of a license be a little bit offset from any change in GOCO contractor that would happen. So in fact, this is what many of us lived back in the fall of 2015, where you saw the GOCO model be put in effect, a switchover of the senior leadership, and then the license, of course, just carried on. There was no hearing at that particular time. And then there was a bit of a period where the new leadership could come in, develop their plans, and then at an appropriate time, they could really turn their attentions to a relicensing process, which for all organizations involved is a very, very significant effort, an effort that of course has value, but an effort nonetheless, and could be prepared to come and present to the public and the Commission and all other interested parties actually what their vision would be for the long term, which is one of the things I think that is of interest and would not be possible if the new management team was coming in fresh, just as brand new leaders in an organization.
Thank you. Question? Dr. Dmitry?
Thank you. This is a question for CNSC staff, and just to give me some assurance. So the intervener talked about the Nuclear Legacy Liabilities Program being canceled. Now, do I interpret that as it's been transitioned to something else? Has something else picked up the liability that program was meant to carry? I see by your intervention by the CNSC, CMD, that the nuclear liability insurance components have all been met? And how does this fit into it? And has it been transitioned to something else?
Thank you for the question, Haiti Tadros, for the record. So I'll ask Mr. Ron Stenson with the Nuclear Laboratories and Research Reactors Division to explain a little bit about what happened to the Nuclear Liabilities Program and where it's at right now.
Thank you. Pardon me. Ron Stenson for the record. CNL will be able to qualify this with better detail, but functionally, all of the responsibilities, the requirements, the liabilities, and the management of those liabilities was absorbed into the ongoing waste management and decommissioning programs under CNL, so that the actual activities themselves, the liabilities were not lost. They were assumed with the through the GOCO contracting by the management company. So they could provide better details on that, but staff is satisfied that the ongoing programs and then the future direction of the disposition, the speed at which they may choose, or the priorities they may want to set were affected by the new direction. But all of those things that were covered under the old liability program were absorbed and into the new waste management and decommissioning program. And they could talk about the funding and so on as well, I think.
David Cox for the record. I'll ask Kurt Keeler to provide some additional information about the Nuclear Legacy Liability Program in its current form. And if necessary, Dr. Quinn from ACL may also be able to provide additional insight from ACL's perspective on the programs.
Kurt Keeler for the record, Vice President of Decommissioning and Waste Management at CNL. The comments Ron made are true. The program continues. It's just not tagged in LLP anymore, the National Nuclear Liability Program. We track it within Decommissioning and Waste Management as an ongoing program, track the liability, and as part of discussion earlier today with the Comprehensive Preliminary Decommissioning Plan being revised, you know, the number associated is the estimate is what backs up that Comprehensive Preliminary Decommissioning Plan and also the guarantee. And so on an ongoing basis, we track it like we would do almost any project baseline.
So to the intervener, now that you heard this explanation, can you maybe explain what did you mean by NLLP program canceled? Because I thought it was just transferred. So what am I missing here?
Well, there's been I think it's semantics, whether you say canceled or transferred, but it's clear that Natural Resources Canada no longer has a nuclear legacy liabilities program. It no longer gets parliamentary funding and administers that program itself. That ceased in September 2015. Now, the parliamentary appropriations for decommissioning and waste management go directly through ACL, and most of them go to CNL. I think this has been sort of discussed here already. But there is nonetheless a concern that there have been some fairly major changes as a result of that transition. In particular, the Comprehensive Preliminary Decommissioning Plan that Mr. Keeler just mentioned and that Nan Tron mentioned earlier in his CNSC staff presentation is being radically changed. And there's a new CPDP for short that's been submitted as of December 12th, which includes, for example, the proposed near-surface disposal facility. And there were activities under the former decommissioning plan that was generated by the Nuclear Legacy Liabilities Program, such as development of an intermediate level waste repository that have essentially ceased as far as we can tell. There was to have been initiated a siting process for intermediate level waste, which is some of our greatest concern, that hasn't even, we haven't heard anything about that today, and nothing in the CMDs either. So there seemed to be a major new shift towards a engineered containment mound, which initially was to take intermediate as well as low-level waste. Now it's only low-level waste. We're wondering, well, what happens to the intermediate level waste? What happened to the program to deal with intermediate level waste that was in the former comprehensive preliminary decommissioning plan? So these are not trivial changes. These are major changes.
No, but with respect, they acknowledge they have to update their preliminary or decommission plan. But I just want to make sure that everybody understands the liability responsibility exists. It did not disappear. It wasn't canceled. Okay, I just wanted that to be clear.
Well, we're still puzzled as to why the reference to nuclear legacy liabilities has simply been removed from the license. That seems inappropriate, but more fundamentally, the liability is still the responsibility of the taxpayers of Canada. There hasn't, that would...
Okay, we heard this argument, we're going in circles, as long as there is somebody responsible, so it didn't disappear. That's all I'm trying to understand. The liability exists, somebody will take responsibility for it. Dr. Quinn, you want to say something about that?
So maybe just for clarity, what happened as part of the restructuring of ACL was a consolidation of Canada's responsibilities for radioactive waste. And so at that time, Canada's responsibilities under the NLLP, which was previously administered by Natural Resources Canada, those responsibilities moved to AECL. So the Government of Canada fully retained all responsibility for all of the radioactive waste. It just shifted from being administered by Natural Resources Canada to being administered by AECL, an agent of the Crown. This is one example. There are other examples. So the liabilities associated with Port Hope, they similarly at the same time were moved as part of this broad consolidation. The idea being that at that time, under the new GOCO model, AECL was purposefully rebuilt from the ground up as a small but highly qualified, competent organization to manage AECL's responsibilities, both with respect to enabling science and technology, but also with respect to fully discharging Canada's radioactive waste responsibilities. And so AECL, with that highly qualified and competent workforce, was given full responsibility for overseeing all of those legacy liabilities, and that is what we do. And so we do receive appropriations from the Government of Canada, which then in turn go to CNL to pay for the costs of them doing the day-to-day work to discharge those liabilities. One of the things that I would point out that's a bit of a nuance is that this liability, which is currently estimated at $7.6 billion, it is booked on the public accounts of Canada. The effect of that is to say that the Government of Canada has already fully set aside all of the funding required to fully remediate all of those liabilities. So those monies and that financial hit has already been assumed by the Government of Canada. And now AECL is contracting CNL to undertake the work to do all of the appropriate environmental remediations and to manage and in some cases dispose of those radioactive wastes.
Thank you. Question? Question? Mr. Seeley?
Not to belabor the license condition handbook and clarifications of previous license conditions versus what's in the new one, but I think we had a very good example of how it could be misinterpreted just by leaving out CSA 290, for example. Is there, this is a question for CNSC, is there some kind of comprehensive table that does a full summary of here's the old handbook and here's where you find it in existing standards, regs, and such that we can give some confidence to the publics that we are not deregulating and that in fact all those requirements are just prepared in a new form and in a new format in the license condition handbook.
So I'd like to piggyback on this. So there is a supplementary that staff produced, CMD 18H 2.A, that has a table in it that deal with the current LCH and the new. I just wonder whether the intervener had a chance to look at it, and are you satisfied with the explanation?
Well, the supplementary compares the current license and the proposed license. The supplementary does not compare the current handbook and the proposed handbook. There are literally hundreds of pages of compliance verification criteria in the current handbook that are not in the proposed handbook, many of which may be substituted by either internal Canadian Nuclear Laboratories documents to which we have no access at all, or CSA standards, and we've discussed those. But to my knowledge, there has been no detailed comparison to assure the public or that the provisions in the current handbook have not been lost and we're not experiencing something called deregulation.
You know, we're dealing in theoretical thing, but in your submission, you gave an example of, let me pick the first one you mentioned was the management system. Okay, so I'm trying to really understand if there was something missing, let's say, in the management system. As it's written here, I'm looking at your intervention on page 4, and you quote the license. And then if you look at the supplementary, staff went through their interpretation of what the new one. What I'm trying to understand, if you had a chance to read it, are you happy with the suggestion that it's not changed really?
No, I wish I were, but no, I'm not. That's why I'm here, is because, well, for example, in that supplementary, they actually extracted one of our comments, and that specifically dealt with having a written safety policy, which seemed like a very good idea and something that every one of those 2,800 employees at CNL could hold up and know what the written safety policy for the labs is. That's gone. And they tried to say, oh no, there's some CSA standard or something that deals with this, but having a compliance verification criterion that says have a written safety policy seemed very important.
Staff?
So Haiti Tatters, for the record, we've discussed a lot with regards to what is there, what isn't there, what should be there. I think from CNSC staff's perspective, and Mr. Seeley, you asked for a comprehensive table. The supplementary CMD with the table at the back was our attempt to show that based on what is currently found in the license and the license conditions of the Chalk River Laboratory site has been mapped to what is proposed as the new license conditions according to the standard set of license conditions that are found in every Class 1 facilities, uranium mines, and mills. So the standardization of all licenses across major facilities is a component that we are looking at here today. And then from there, we took all of the compliance verification criteria that currently exist within regulations, within CSA documents, within reg docs, and within the licensees' programs, and cited them as compliance verification criteria that are used by CNSC staff when they conduct compliance verification inspections, desktop reviews. So the point that is very important to make here is these documents are enforceable, and these documents are used by the regulator and the licensee. I understand the significance of understanding these documents from the public's perspective, and I think Dr. Hendrickson has gone through an extensive exercise to just point out what I believe is some confusion as to what might be missing. We are looking at how to bring forward the recommendations of potentially CSA standard N292.0 as compliance verification, even though it is already a requirement by reference. So we are looking at improvements in terms of what can we bring forward into the compliance verification criteria that are found in the LCH. So with that, I believe Mr. Ramshi Jamal wants to make some statements around the license and license condition handbooks in case I've missed something.
Term Jema, for the record, I commend the intervener for taking his time to really evaluate and request clarification. At the same time, a discussion took place about the GOCO, the term of the license. I'd like to remind everybody that we have the Act, we have regulation, and the license condition handbook. The Act is the law. In our supplemental CMD, we clearly identify that every licensee must be in compliance with the Act and the regulation. The license condition and license condition handbook, there are the regulatory instrument with respect to complementing the Act and the regulation. And I would like to inform the Commission and the public that the CNSC did not go into this licensing process blind. We had international benchmarking with our counterparts where the GOCO program existed. We've taken lessons learned from a regulatory perspective, and we did never recommend it to the Commission, the transfer of the license or the changes without us taking in consideration what lessons learned did take place. In addition, the license condition handbook is not unique to the CNSC. When the CNSC went into the binding treaty, a Convention on Nuclear Safety or the Joint Convention, we introduced the license condition and the license condition handbook, and the ONR, which is the UK regulator, has actually adopted that system, and they put in place, as of February 2017, a license condition handbook that clearly states that there are as a matter of fact, the license conditions are much more general than our license condition. We match them to each SCA, and Mr. President, you talk about changes. You mentioned the management system, but if you take the existing license condition 2.2, I just want to clarify the fact to the intervener with respect to the language that we say we cleaned up in the licensing process. So if you go to page 5 of 32 of the staff supplemental CMD, license condition 2.2. I will read the language. The licensee shall monitor the safety performance of the CRR facilities and upgrade them when substantial risk factors not recognized earlier appear during operation or through research findings or revised safety analysis. From a regulatory perspective, I think this is ambiguous language. Compliance verification was not clear. We moved over to the proposed license condition 3.1, that the licensee shall implement and maintain an operating program which includes a set of operating limits, and we go on. If you look at the LCH, the CVC requirement specifically talks about taking into consideration operation limits and conditions that include requirements to review and revise operational limits and conditions due to changes in technologies, regulations, operational information, physical regulations, and the outcome of safety analysis. So this is the clarity and compliance verification we are introducing into the LCH. Because the intervener mentioned the compliance verification that are being used by our inspectors. We have our inspector on site here. that the CVC determines the clarity of the licensee in order to comply with the license. Our staff take the CVC from the license condition handbook. It is not the only regulatory instrument. We have the regulation that the licensee must comply with, and I'm going up to the pyramid to the act itself.
So I'd like to bring some conclusion to this. I'd like to hear from staff, are you satisfied that nothing is being lost because the intervention alleged that something like 20, out of memory, 26 conditions been eliminated? Are you telling us that they were not? And from CNL, are you telling us they're not? And you're telling them that they were. So somewhere along the line, we got to reconcile this. So why don't I start with staff? Your view is there's nothing has changed in reality, in requirements.
Jean Leclerc for the record. So just to be clear, and I believe we've made it quite clear in the supplemental, the license conditions that have been removed are specifically associated with NRU, which are because the situation with NRU, as we've now mentioned a number of times, is changing as of the end of March. So that is a change. So, and we've been clear on that in the supplemental. In the table, we've mapped all the license conditions and shown what the new license condition is and tried to show quite clearly how those requirements are captured in the LCH. So that's what we've done. We've gone through this. It was quite an exercise to do this, but we believe it's provided a lot more clarity on that. I do want to take just a moment, though, to touch on Mr. Seeley's comment, because he did mention a comment about mapping, and I want to explain to him, hopefully help him appreciate some of the challenges. So if we just take an example like record keeping, the intervener mentioned record keeping as an issue that we didn't talk about record keeping. Well, the management system standard, N286, says thou shalt keep records. In fact, in our supplemental, we said the Act says that you need to maintain records. The General Nuclear Safety Control regulations say you need to maintain records. And a lot of the other regulations talk about records. So records, if by now licensees don't know they need to keep records, I think we've got a much more serious problem in our hands. But that being said, management system says you need to keep records. That means you need to keep records for every one of those safety control areas that you see listed. So there's 14 safety control areas. If I were just to take that as an example, and that has in fact been the challenge with this current license, if I really wanted to be precise, every license condition associated with every safety control area should say you need to keep records. Because someone might say, well, it says in waste management you have to keep records, but it didn't say that for physical design. So we went out and destroyed all our design records. I'm exaggerating a bit, but only to try to get across the message that the whole idea and the whole premise of what we've tried to do here, we've put a lot of effort in getting 14 safety control areas. It took a lot of discussion internally within the organization to come down to those 14 safety control areas. And what we try to do is make sure that we don't replicate them within themselves, because when you start doing that, that's when confusion starts to happen. That's when things start to get mixed up. So if I just use that as an example and said, within every safety control area, I had to talk about the other safety control areas, then the matrix would be 14 by 14. Using some simple math, you could just imagine the size of this thing. So as we've gone through, we've made sure then, so I don't need to say records management is important for waste management explicitly, because I already said it under management system that says you need to keep records. And it means you've got to keep records for all the things that you're doing. So it's covered. And that's why it's a little bit of a challenge when and this is the challenge with that current license, is we have some words that have been put into a certain license condition at some point in time for a reason. That was because maybe waste management record keeping was was an issue at a license hearing at some point in time, so the word record keeping got added to it. But we didn't add it to any of the other ones. But yet, we know it's important. So I hope this helps to try to clarify that really when you look at the license conditions handbook, that framework of those 14 SCAs, and then bringing it across and tying it to those regulatory documents helps to make sure we've got it all covered. Again, I'll reiterate though, we are going through it. We still have to go through that LCH. We will wait to hear back from the commission following this hearing. And with all that information, we still have to go through our final review of the LCH because we have a vested interest in making sure that we haven't lost anything, because it makes our job easier when we've made it very clear to the licensee, here are the requirements, and so that when we come in and do our compliance verification activities, it's clear to everyone, our staff and both the licensee.
Mr. Lamar?
Maybe just on since you were addressing that to me, just on the issue of records. So trying to simplify and cover it off in the management system, thou shalt keep records. But that's a very broad statement, and it would be certainly, I'm sure the Nuclear Safety Control Act defines what elements of the program need to have records, and I'm sure that needs to be defined in the license control handbook. So saying it once doesn't cover it. You need to point where, exactly what you need to keep records for to meet the regulatory requirements.
But just to re-clarify, perhaps I should mention, when you go and you look at the standards, the CSA standards, and you look at the regulatory documents, the word record management comes up repeatedly in those documents as well.
Mrs. Jamal?
Mr. Representative, for the record, I'll give you a couple of examples, but I think we're turning a factual discussion into a virtual discussion. That's my fear. The key point here is we make reference to the CSA standard that incorporated our regulatory experience in the CSA standard. In every CSA standard, there are two components where applicable. There is the component with respect to what the industry should do in order to meet the CSA standard, and there is the regulatory compliance element that we, the CNSC, adopt, and we put it into the license condition handbook with respect to the compliance verification. So the CSA standards contains, when we make reference to CSA standard, contains regulatory requirements that the CNSC has embedded into the CSA. The CSA standards complement our act, our regulations, and our requirements because it's always improving with the time. So if you go with the question that the President asked, did we eliminate conditions or did we remove conditions? He didn't say eliminate, remove conditions. What is pertaining to the non-applicable license conditions with respect to the operations, yes, they were removed. There are specific ones for the NRU. I'll just walk you through two examples. With respect to the license condition that existed by numbers, we did incorporate them into CSA standard that clearly states what are the requirements from a regulatory perspective. So we did not repeat it multiple times. So I will take you now to existing license on page 18 of 32, which is the table. Existing license condition 4.12. It says the licensee shall develop and implement and maintain a program to collect, screen, and analyze document operating experience and events at the CRL site or reported by industry in a systematic way, and to apply the lessons learned to activities at the CRL site. Now the management system, as it's referenced in our license condition handbook, clearly describes the requirements by the licensee in order to take lessons learned, to report events, and we have regular RDs that are coming out with respect to reporting to the Commission. So that license condition was incorporated into license condition of the proposed license 1.1, which clearly stated that the licensee shall implement and maintain a management system, which has the specific requirements within that management system in order to report events and take lessons learned. And we do inspect management system. We have specialists in the organization that they do establish guidelines to our inspectors to inspect the management system. That is our continuous enhancement with respect to improvements in regulatory oversight with respect to clarity. So that's the key point here. With respect to the NRU, that does not pertain to an existing operation, the license condition was removed. So this is what we're doing with respect to putting together, without compromise to safety, the requirements with respect to regulatory oversight. Again, the regulatory oversight, the compliance activity. As a matter of fact, we have examples. We have imposed additional requirements on the licensee that we did not have before, according to our regulatory experience. And I will leave it at that.
Okay, the bottom line, you're saying that you're satisfied with the LCH as written, that it'll meet all the requirements that you thought was in the old one. I'd like to move on to CNL. Are you of the same view? And then I'll give you the final words about your thought about that. CNL?
David Cox, for the record. So CNL has reviewed the draft or proposed license and license condition handbook, and we are satisfied with the content. We've looked at, as I said before, the code standards and reg docs that are referenced therein. Having said that, I'd like to ask our Chief Regulatory Officer, Sean Cotnam, whose staff have been involved in the detailed review of those documents, to provide his additional comment.
Sean Cotnam, Chief Regulatory Officer for the record of CNL. So I would have answered Commissioner Seeley's question the following. When I first got the supplemental H2A, supplemental CMD from staff, the first thing I did was read the first, I think, 23 pages through the conclusion. Then I took the back 33 pages and I sat down with our current license and the proposed license, and I mapped them, license condition to license condition. And when I was done that evening, I had accounted for all 27 and all 56. And as I think Mr. Jamal has pointed out, the CVCs are in there. So since Mr. Jamal took us to the same page, I think it was 18 of 32, I'll use another example on that same page. It's actually page 17, where there were two previous license conditions on pressure boundary inspection. One of them said you should implement and maintain a pressure boundary program, and the other explained that you would have a A1A, well, that's slang, authorized inspection agency to do that. The new license condition is one license condition, consolidates two, says the same thing. So when I was done, it was three simple categories. A first category that were no longer relevant because the changes for NRU has been pointed out. Those that were consolidated and added clarity, in my view, and a third set which were like-for-like replacements. And I was done. Everything fit in those three categories, full stop.
Well, if you have done already the analysis, invite your neighbor over and show him, maybe you can have a little discussion and show him, and you can have the argument about whether it's done or not.
Dr. Hendrickson and I can go over that at the next Environmental Stewardship Council meeting.
Over to you.
Little did I know when I prepared our CCRCA submission and called for revised staff document that has an expanded, that has a description, that has a section on proposed license changes that fully documents and explains these license changes, that it would lead to a 2-hour discussion or whatever we've just had. I think it is non-trivial, though. This is a serious matter, and we could spend 5 times more time looking at this comparison, and we didn't even get into some of the changes that for example, the current license says that that decommissioning activity shall be approved by the commission, or new construction of new facilities should be approved by the commission. Maybe there's some way that that's covered that I don't understand, but we could go on and on and on. And clearly we don't agree about this. But I think what we can all agree is it's important for the regulator, it's important for the licensee, it's important for the public to have as much clarity about what the compliance requirements are for a licensee, what a licensee is supposed to do to keep us safe, to protect the environment. And I just don't see it in what's been proposed here. I'm sorry. I would love to see a much clearer document, and I think the current license condition handbook is much stronger, much clearer, and it acts as that single point of reference. You don't have to have a huge shelf of CSA documents and reg docs and so forth. It's there. So I still don't understand why we can't have that sort of approach to a license.
And you don't believe that the annual report on actual performance will give you a vehicle or a window to see what actually happens and question what actually is happening?
It's an important thing, but it doesn't offer opportunities for people like myself to intervene and express concerns. Just like in 2016, when the 17-month license was given, we could only make written submissions, no opportunity for oral submissions at that point, and that's a real limitation.
Okay, thank you. Anybody has any other final? So thank you for all the work.